Cancellation of removal, this is a crazy topic, but it also shows some real gay animus in it. A lot of people say, isn't there a rule if you hear 7 years, you can become legal? We used to have a thing called suspension of deportation. If you were here 7 years, if you were a person of good moral character, and if you or your parent, spouse, or child would suffer extreme hardship, a judge could suspend deportation and give you permanent residence. So about 15 years ago or so, we were able to get a number of lesbian couples protection by having the foreign national apply for suspension of deportation, prove that she would suffer extreme hardship because she would be separated from her partner. Now the judges would say, wait, that's not a marriage, it's not extreme hardship to the partner, I can only look at hardship to the individual foreign national. But we were able to convince the judges that the foreign national's hardship was multiplied or exacerbated by the fact that there would be separation from someone that she loved. As we started to win on some of these, they changed the law. So suspension of deportation became cancellation of removal. Not 7 years, but 10 years. Good moral character still, but not just extreme hardship, but extreme and extraordinarily unusual hardship, and not to the individual, only to the parent, spouse, or child. And since most gay people, well, first of all, they weren't going to be able to get married back then, and they wouldn't have those anchor relatives, the parent, spouse, or child, it wiped it out as a source of protection for our community in a great way. It didn't just hurt gay people, it hurt lots of other people too, but the animus, we believe, in when that was rewritten was really because some gay people were getting around the restrictions of having our relationships recognized in some capacity. Registry is if you've been here since '73. Kennedy tried to get this changed too. If you were here before '73, you can apply for permanent residence. It's like a permanent amnesty. So what Kennedy tried to do was to get the date moved up about 10 or 12 years and then have it roll forward constantly. So there would be, in effect, a permanent rolling amnesty, but it never went anywhere. There are other laws that come in and sometimes last, sometimes don't. The Cuban Adjustment Act is still in the books. VAWA, which is extremely important, Violence Against Women Act, protects people who are in relationships with U.S. citizens and are being abused. And it allows them not only to get away from the abuse, but to remain in the United States in safety. You'll see other acts come and go. What we hope is going to come here, and I know Ben is going to talk about this, is comprehensive immigration reform. So sponsorship by family. You can only sponsor family members if you're a U.S. citizen or a lawful permanent resident. You cannot sponsor if you're an F or something like. You can have your wife here if you're an F or your husband here, but you cannot sponsor someone for residence unless you are a U.S. citizen or permanent resident. And the citizen can sponsor those relatives, and the permanent resident can only sponsor the spouse and unmarried son and daughter. Parents, spouses, and unmarried minor children are immediate. There's no waiting. If they will recognize our relationships, you can sponsor your spouse and have a permanent residence in 5 months. Boston's the fastest big city in the United States right now. But again, they don't recognize our relationship. Brothers or sisters, the category is backlogged over 10 years. So some have quotas, some don't. And you have to determine where you're going to be, who can sponsor you, how long the line is, etc. There's a lot of strategizing that goes on with this. No other relatives are sponsorable. No aunts, uncles, nephews, nieces, grandparents, in-laws, etc. It's just these relatives. And yet these come up with 300,000 to 400,000 people a year. So this category is extremely important, and that's why we've got to beat DOMA. Because this category is where straight people get their major benefits, and we don't get them generally. So this is where the struggle is for us on DOMA. DOMA blocks that spouse from sponsoring the spouse, and we'll talk about that just a little bit more. On the employment-based, I'm going to move quickly. Where are my time-wise? 5? Okay, sorry about that. Employers in the U.S. can sponsor people in these categories, and in 2 of them you can self-sponsor. If you're a person of extraordinary ability, you can self-sponsor, or you can have an employer sponsor you. And if you're in the EB2 category, either a person with a master's or exceptional ability, you can self-sponsor if your work is in the national interest, which sounds extremely highfalutin, but it doesn't have to be that. There was a woman in New York who wanted, because she's an engineer, and she helped redesign bridges so they would be less susceptible to earthquake damage. Well, that's movable throughout the United States. It helps the intertrade transportation system, so that's possible to work as a national interest waiver. So the extraordinary ability or the master's degree one, if your work is in the national interest, you can self-sponsor. The rest you have to be sponsored by a U.S. employer. This and the non-spousal family categories are available to all of us. And these are the routes you really need to plan for. If you are hoping to rely upon the relationship, it's probably not going to work for a while yet. So what you need to do is hold on to some of those non-immigrant categories, remain here, remain viable, remain legal, and then seek out one of these employment-based categories to see if that can move you in the right direction.